What is copyright?
Ryan Schmidt is an entertainment lawyer and an expert on music law.
Spotify is under a court order to pay a certain amount of royalties to the songwriters.
Who appoints these judges? There's no judges appointed that will just decide, like the free market will decide.
If somebody else is doing that without your permission, that is now copyright infringement.
In this conversation, we dive into the messy world of copyright. What is it and how does it work? We talk about the Blurred Lines trial featuring Robin Thicke and Pharrell Williams, and Ed Sheeran's heroic battle for the future of songwriting.
The music industry has forever changed ever since that Blurred Lines decision.
This is a good one, so pay attention to my friend Ryan Schmidt.
Let's cut straight to the chase. I asked you to come on because I wanted to. So many things that I could talk to you about, and I know that you're very knowledgeable, but there's one thing that I think that everybody has heard about, but most people don't know exactly what is, and I'm talking about copyright. So my first question is, if it's possible to answer in a simple, clear way, what is copyright?
Copyright is a limited monopoly that you, the creator, have in your creative works.
That was quite simple. Is it because there's, of course, copyright in music, where we're going to spend our conversation, but you have copyright for medicine and all of the kinds of things. Is it the same thing, or is it different depending on the industry?
There's copyright. When we talk about copyright, we're usually talking about some type of creative work. It can be a choreography, it can be a film, it can be a book, it can be music, it can be a sculpture. When we talk about things, and I'm speaking to the American intellectual property system, when we talk about other types of protections in maybe medicine or technology, you might be looking at patents that protects like scientific discoveries and formulas and that sort of thing. And you also have trademarks, which protects like logos and brand names.
Okay, so when we use the term copyright, it refers to creative work, creative assets.
Yeah, so copyright, when we talk about copyright, we're really talking about protecting creative expression.
Yeah, I see. And you said that there's some limits to this. What's the limitations?
The biggest limitation of copyright is that it is for a finite period of time. You can't create a work and then that work is going to be protected for the next 1,000 years, and your great grandchildren are going to be able to profit off that. In America, the U.S. Copyright Act says that the length of the copyright protection you have is your life plus 70 years.
Yeah, exactly. It's the famous case of Winnie the Pooh and Mickey Mouse, right? That's, do you know is that the life of Walt Disney plus 70 years, or is it?
So the stories about both Winnie the Pooh and the original Mickey Mouse entering the public domain comes down to an older copyright statute. Right now in America, everything is under the Copyright Act of 1976. And that's the most recent Copyright Act that we have. Yeah. Prior to that, there was a Copyright Act of 1909. And that lasted from 1909 to essentially January 1st of 1978. And under that copyright, certain works are now reaching the end of their useful life. Winnie the Pooh, for instance, and the original Mickey Mouse both aged out. That was 95 years, and they both entered the public domain within the last 2 years.
Okay, but let's talk about copyright when it comes to music. So from what I know myself, there's two major types of copyright in music, right?
Yes, when we talk about the music industry, there are two main copyrights. There is the composition copyright and the sound recording copyright.
Yeah.
The composition is also known as your music and lyrics, and the industry is the publishing industry. You got your sheet music, your mechanical royalties. On the sound recording side, it's often known in the industry as the master or the master sound recording.
From what I understand, things have changed there because the publishing side, that's that's if I write a lyric or I write some chords, and that's kind of the if I write down the chords and the lyrics, old school style when you had like the guitar books, that's the publishing side of it, or the notes if it's like a orchestral work, and if you have the master rights, that's kind of the CD, right, or the LP, or
Exactly. Yeah. So think about it that the composition side is writing down some lyrics and some chords onto a notebook, or it could be, you know, on some sheet music. And the master could be pulling out your iPhone or opening your favorite DAW and recording your composition. It could also be spontaneous, though. It could all happen at the same time. You could just open up any type of recording software and improvise a song, and now you are both writing the composition and creating the sound recording at the exact same time.
yeah. And for it to be a copyright, I would have to write it down or record it. I can't simply think of it or write down that. For example, I can't write down a song name and say I've written this song and then prove it. Then I can just how is that? How are those rules?
So copyright is going to give you an automatic protection from the second you put it in some tangible means of expression. And what that means is the second I write it down on a piece of paper, second I pull out my iPhone and I record it, I'm now going to have that protection. It's not going to protect the ideas that just live in my head, because that's the difference between the idea and the expression of the idea. And if I sing in a room by myself and I don't write it down, then it might be lost forever. But generally, you want to record it, you want to write it down, you want to put it in some tangible form to get those protections.
Yeah, but I don't have to register it somewhere for it to be a valid copyright.
Correct. Yeah, registration doesn't equal ownership. Registration just gives you additional protections in this copyright that you already have.
But it gives you, it sounds like a smart thing to do. If you and if you're in the same room and I have a song and I've written it down, I said, this is my song, but you run ahead and you register that very song in your name, I think I would have some problems, maybe.
Absolutely. It's smart to register your copyrights, because that creates a public record of both when you've created or published the work and who owns it. So I generally recommend that you go ahead and do that, and you also get all these additional protections like being able to sue, being able to get certain statutory damages, and being able to collect your attorney's fees. So those are all big things. Even though you get automatic copyright protection the second you create it and put it in a tangible means, if somebody steals your song, you're going to have to register it anyway to be able to file that lawsuit.
What I understand, there's been this change, or there's been several changes in the music industry, but when it comes to publishing or copyright, it used to be that the publishing side was kind of more valuable, but now in the streaming age, the master side is the most valuable, or am I completely lost here?
You're absolutely right.
Okay.
The music industry started, when the music industry started, there was no sound recording. There was no device that was able to capture and recreate recorded sound. So sheet music and publishing predates any type of sound recording. And in fact, there wasn't even a federal U.S. copyright protection in sound recordings until 1972. Way after we had, vinyl and LPs.
Yeah,
and
that's
all these crazy things. So yes, publishing did predate it, and it was by far way more valuable, way more lucrative. And then as the recording industry really ramped up, it became more of an equal split. Since the streaming era, there has been a real shift that the master sound recording makes close to 70 to 80% of the royalties that come in on a stream or a download, and then the remainder of that is made on the publishing side.
Yeah. So the songwriters union slept on the job there, I guess.
Well, not yes and no. This is all, especially in America, this is all comes down to very hard fought legal battles. There is a copyright royalty board that meets every 5 years, and they determine what the royalty rate is for songwriters every time a song is streamed and purchased on digital platforms. And that royalty rate was stuck at a certain cent for years and years and years. And the songwriters and the publishing associations would fight to get a raise, and the big tech companies like Spotify and Google would fight them tooth and nail, and it would stay the same for years and years. And we finally got a big raise in 2018 with the Music Modernization Act and new rate changes. But Spotify had fought that so hard that stayed on appeal for the next four or 5 years. So we didn't get paid out those increased royalty rates for a few years after those rates did increase.
Yeah, but okay, there's so many questions here. Number one, you said there's this copyright board that decides what the royalty rate will be, but who is in that board? It sounds like this board has some type of insane little governmental power of sorts.
It is a 3-judge panel sitting in Washington, D.C. They've got tremendous power to determine how money is made for songwriters and publishers in the music industry. And they have a tough job of hearing arguments from both the creative community and from the commerce side of things on how those royalties should be set. There is currently a 5-year plan that will incrementally increase the royalties each and every year. The problem is, if you've been following what's going on with Spotify, Spotify is under a court order to pay a certain amount of royalties to the songwriters. They don't have that same type of obligation to the master recording, but since labels are co-owners or equity partners in Spotify, that's how we've got the 70% that they have been taking. But Spotify is required to pay 15 to 18% of their revenue to songwriters and publishing. It's going to slide up each year, and that was fine. That was a pretty predictable royalty rate. But Spotify just started bundling their accounts. So now they say you previously paid $10 for a music account. It's going to be 15% of that $10. Now they're saying, since this is actually an audiobook, podcast, and music bundle, we're going to prorate the music side of it, so songwriters are actually getting paid less. There's a big legal battle that will be shaking up there, whether or not that's really what the parties and the Copyright Royalty Board intended when they set these rates.
Yeah, this is complicated, but who appoints these judges? And because to me, I'm from Norway, but to me, America is like the home of competition, and there's no judges appointed that will just decide, like the free market will decide. But this sounds very un-American to me.
Yeah, so federal judges are appointed typically by recommendation of the president, and they're confirmed through Congress.
Because they're not music people. They don't have any idea. Like they are intelligent people, I would hope, and they will have to learn the case, listen to the experts, and then make a decision.
Absolutely.
Oh, this is okay. So we have to. So Spotify is of course doing their job as a cynical tech giant, trying to slip the slope around these new rules and find a way where they of course pay their owners more than the lonely musicians that does not have the power and the influence and the knowledge to change things, I guess.
Absolutely.
But okay, yeah, that's I guess that was kind of clear. But you understand, this is quite complicated, I guess, for most people. I'm quite into music, but I haven't I know there's stuff going on, but I haven't dug into it like we're doing now.
It's absolutely complicated, and to be fair, the entire music industry was intentionally created to be a pretty complicated system, so that the balance of power and the control of money stayed in the hands of the companies. It was supposed to be something that confused artists, so they didn't know how bad their deals were, that they would just gladly sign these things and not understand the consequences of them.
So, but the real loser, because from what I understand, this change has also kind of changed the deals that artists sign with labels. So now, from what I understand and from what I've experienced myself, is that you get master rights. That's a part of the deal most of the times. But the real losers here are the songwriters, the people who are simply writing songs. If they used to get paid like 50% or half the cake, and now they get 15 to 18% and still being scammed.
Songwriters are having a really tough go right now. It used to be that people used to sell albums, and if you were on a platinum selling album, even if your song wasn't the lead single, you were going to make money because those royalties are paid out regardless of if I buy the CD and I only listen to the first track or I listen to all 10 of them. So the sale of physical records was huge for songwriters, and that's something, the moving to singles and moving to the streaming age really harmed songwriters in that way.
Yeah, it harmed the music, and it harmed music because now we only try to make these. Everybody tries to make super hits or make the simple 3-minute songs, but that is a different topic. Let's briefly talk about sampling when it comes to copyright. In the 90s hip hop, they sampled everything, and they didn't necessarily know how to clear the sample or ask for permission before they released it. And that thing is still an issue. What's the rules there?
The rule is that the Copyright Act gives you certain exclusive rights. That's why I say it's a limited monopoly. It's limited in time and it's limited in scope. But you, as the owner of that work, have the exclusive right to take certain actions, like the right to reproduce your work, to perform it publicly, to distribute it, create derivative works. So if somebody else is doing that without your permission, that is now copyright infringement. So if I wanted to use somebody else's sound recording, which is a copyright, and I wanted to put it into my song, I'm reproducing it and I'm creating a derivative work of a pre-existing song. I can't do that without the permission of the original owner. That's always been true legally, but the climate has changed. There used to be that people were more accepting of samples being used that weren't cleared, songs that were heavily, heavily inspired by other songs being written and being out there. Now it is a far more contentious, litigious copyright landscape for musicians.
So, yeah, because from my understanding, people have, it's often easier to ask for permission after the fact. And I think that was what they did. They kind of made these new bangers, then they blew up, and then after the fact, they were like, okay, we used it, but we can probably solve this in a way. But then they've already achieved their goal. So, but now that is starting to change, you're telling me.
Yeah, and it really, you know, I hate to say that it came down to one case, but it really does seem like the music industry has forever changed ever since that blurred lines decision. That there were so many things that were just understood, both in songwriting and in sampling, that you could easily be inspired by something, take an idea from something. And since that decision, it really opened everything wide open, that people are a lot more likely to sue if they believe something was inspired by something else.
We have to talk about that. Like you're saying, the blurred lines situation, and you're referring to the song "Blurred Lines" by Robin Thicke and Pharrell Williams from 2013, I think. It was a huge, massive hit, and then a year later, a couple of months after the release, they got sued by the estate of Marvin Gaye, the owner of the sound recording, I guess, the company on the sound recording, that claimed that they had not sampled, but they had been more than inspired. They've kind of stolen the beat in a sense, but these things are very hard to pinpoint.
Yes, so you're absolutely right. The Blurred Lines case argued that the song Blurred Lines by Robin Thicke, Pharrell Williams, and T.I. took protectable elements from Marvin Gaye's Got to Give It Up. And the estate of Marvin Gaye argued that they took both the feel and the vibe of this song. And before that case, that wasn't something that was generally protected under copyright. It was lyrics, melody, and some type of harmonic element were usually the things that were protected. You know, we're talking about a guitar solo, a top line vocal melody, lyrics, not a general theme
Vibe.
or feel. And think about how many genres are created to have that same feel. And the blues is set up on one specific structure and feel, you know? So that was pretty surprising and a pretty new legal argument. That court found that Marvin Gaye, in that situation, Marvin Gaye's family was right, that they believed that there was copyright infringement and that you could steal a feel and a vibe. And that really expanded what a copyright infringement lawsuit could look like. And it's had a lot of impact on the music industry because up to that point, everything was inspired by everything else.
This is my issue with how law is being practiced today, that you have this thing called legal precedents, right? So if you have some, dare I say, idiots that make a decision that is maybe not correct, but then they still set this precedence for the in perpetuity, or at least for a long period of time. What do you think about that as a lawyer yourself, entertainment lawyer?
Well, first is the idea of precedent itself. There's non-binding and binding precedent. A trial court decision is only going to be binding on the parties that were involved in that specific lawsuit. Where we create binding precedent that extends beyond that and creates new law is when the parties appeal and they go up to higher courts of appeals. So if it just stayed in the trial court, it would only have ever applied to Robin Thicke, Pharrell, T.I., and the estate of Marvin Gaye. Yeah. The parties appealed that decision, and it went all the way up to the Court of Appeals for the Ninth Circuit. And that's out in California. And that means that any case before any of the courts within that circuit, including trial courts, have to follow the decision of that case. Yeah. All the other circuits and all the other courts sitting in the country don't have to follow it. It's not binding on them, but it's very persuasive, meaning that a court could consider it and they could say, I thought that was very well argued and reasoned by this court, so I'm going to adopt that in my court or in my circuit.
Mm-hmm. Exactly. And so it's, but people can go listen to themselves to Gotta Give It Up from Marvin Gaye and Blurred Lines. And there's some obvious similarities there. The beat, to me, it's like they've copied a cowbell. It sounds like they've copied the cowbell there. But other than that, it's two different songs, in my opinion.
No, I think you're right. And another thing that came out of that, not just a larger number of copyright infringement lawsuits, but you also saw songwriters and publishing companies more willing to try to include people in songwriting credit before an issue was created. You know, they could, if as long as somebody said that really sounds like so-and-so's X, they would offer up a chunk of that publishing just to avoid a Blurred Lines type of situation. Like Sam Smith's Stay With Me, Tom Petty's Don't Back Down. Tom Petty owns a piece of Stay With Me because that was presented to him. There was no infringement lawsuit, but they said that the melodic structure of the choruses was very similar. I don't think it was intentional, But the blurred lines case made people want to avoid the expensive process of going through litigation just to lose a multi-million-dollar lawsuit. So they said, I'd rather just offer up some percentage on the front end and be done with it.
There's so much to think about. People just want to make songs and they have to do this. That, of course, that's why we have you. You also had another case also involving Marvin Gaye, but from what I found, it's not Marvin Gaye. It was not Marvin Gaye's estate that did the suing in that instance, but it's this situation with Ed Sheeran. What do you know about that one?
There were multiple plaintiffs on that case, including the record label and the estate of Marvin Gaye.
Okay.
This was a situation where the estate and the record label, again, the same parties that were involved in that Blurred Lines case, sued Ed Sheeran, stating that Ed Sheeran's song, which one was it? Thinking Out Loud?
Thinking Out Loud, I think. Yes, Thinking Out Loud. Yeah.
Copied certain elements of Let's Get It On.
Let's Get It On.
And there, they try to, again, further extend what is considered protectable. In Blurred Lines, they said that a feel and a vibe could now be protected. Here, they said the building blocks, essentially the song structure and the chords.
Yeah.
To which Ed Sheeran said, this is getting ridiculous. You know, if you're a songwriter, you have to be able to use 1-4-5. You know, that is the building blocks of any great song. And there's only so many chords that we can use. And so there, Ed Sheeran took a very different approach than what Blurred Lines did. In Blurred Lines, Robin Thicke had previously gone on the record in promoting the song and saying, oh, yeah, we were in the studio, and yeah, I wanted to evoke a certain Marvin Gaye, Got to Give It Up vibe. And he had actual admissions that he was going for that sound. And then at trial, he tried to deny that and tried to backpedal. In the Ed Sheeran case, Ed said, I understand that these sound the same. They sound similar because they're using similar song structures. But that doesn't mean that I stole that song, because these song structures, the chords, and the building blocks of the song are something that's freely available to all creators. And he won that case.
Yeah, but from what I understand, he did it in a brilliant way. He actually brought his guitar with him, and he played a lot of songs over the same chords. I think that there's this clip on YouTube where he's explaining it and showing it off, how he did it, which is, of course, impactful.
When your legs don't work like they used to before, and then there's, have I told you lately that I loved you? And then people get ready, there's a train coming. And then what was the, looks like we made it. Look how far we've come, my baby. And she breaks just like.
The other cases, the Blurred Lines case, really involved two academics, musicologists, really arguing different positions on the really technical side of music, the notes, the beats, the length, you know, that sort of thing. And Ed Sheeran had a more practical approach. Certainly there were experts in that case too, but he said, this was my songwriting practice, and this is how I go about writing songs, and here's how countless other people have written these songs. And hearing that in his own words, and having a jury really understand, there's only so many chords that you can use and so many different structures that are used in modern popular music. I think that's what really made him win that case.
Yeah. Before we let you go, AI. How is AI? How would that impact copyright?
Right now, the U.S. copyright has taken the position that AI-generated work is not protectable, because to be eligible for copyright, it has to be a work of human authorship. And so when we have generative AI, if you're just typing in a prompt and an algorithm is creating the work, that is not human authorship.
Okay.
Where we're going to get into some real legal issues is how were these different models trained?
Exactly.
We have lawsuits, of course, right now with Universal Music Group, Sony, and Warner suing two major music AI companies, Suno and Udio, saying that these models were unfairly trained, that they scraped a whole bunch of copyrighted works owned by those labels to create this generative AI model. That is going to have a huge impact on the future of AI companies and really sparks this debate of what is ethical in the landscape of AI. I think a lot of people would agree that while AI is a exciting tool and a useful tool to creatives to a certain extent, most people would want, if their work was ever used to train or to create a generative AI work, they would want the ability to consent to it, to be paid for it, and to get credit for it.
Yeah, of course. But don't we also see OpenAI, they're doing deals with not necessarily the music companies, but with other, like with New York Times, they're doing deals with, they're paying the rights holders, I guess, and
They are now.
Yeah,
Right.
they're of course they're now. But where do you see this end?
I do believe that the AI companies that survive are going to be the AI companies that have the permissions. The end user is ultimately going to have to pay for that, because if these companies trained their models with unprotected works that they hadn't licensed and they had it for free previously, and now they're paying millions of dollars for the rights, that's going to get passed on to the end user. I do think that there'll be many inferior models that come up to compete with OpenAI and some of the other more established models. But I really think that the long-term successors in this AI battle are going to be the ones that do it the right way and get the permissions.
Thanks to people like you, because you will sue the unserious ones to death. That's
Yes.
good. Again, Ryan, thank you so much for joining. If people want to know more and find you, where is it easiest for them to find you?
One of the easiest ways to find me is on Instagram. My handle is ryanschmidt.esq. I'm also a partner here at Bowen Schmidt Entertainment Attorneys, and our website is bowenschmidt.com.
Great. Hope to see you soon.
Likewise, man. Thanks for having me.